So what we're looking at here is throwing this out to the group here and the group on extended tape, just so that when you're involved in your matters, legal matters and others, keep your eyes and your ears open to observe what's happening. If we're getting more feedback that these kinds of activities are coming out of these courts, you bet your bippy, these are not accidents. Where we go, they will follow. That's the way it is. The slaves and the servants follow the master. Usually not the other way around. So if we're starting to do things correctly by drafting the attorneys to operate on the private side, it's a perfectly colorable act for the court to grant a motion to the public attorney to quit the job, but then he immediately states, basically outside of his duty, because he no longer has a public duty, that he'll participate in any way, shape, and form he can to help resolve the matter. If that's true, equity said we'll allow this attorney to walk away from counseling and defending the defendant. But the only way they can get away with that is to have the attorney volunteer in private, to do it in a private capacity then, so that they're covering their bases of defending their corporation, which they're liable for. See, the whole purpose of court is one thing. They set up all these corporations that they knew were bankrupt, dumber than a post, had no life in them, attached them to all of you people. Remember all the alien space movies on television, where all the aliens land and they place this little worm inside of you, which is going to take over your body? Well, the little worm, you had a body snatchers. The little worm is your straw man. And they hope now that you do all the dumb, stupid things to give life to that stupid little worm they put in your body that would die without you. And so they hope and pray you do all the dumb, stupid little things that idiots would do, so they control you by that worm they put on you. However, when you say, well, you know, me and the worm are separate, and we're going to just move the court to operate your own worm, then all of a sudden, whoa, something else is happening here. You're not being controlled anymore by the illusion. Yes, Ross.
Make it three. He said the same thing to me. Exactly the same thing. I about fell off the chair.
Yeah, the lawyer said he'd come back and help.
Yeah.
The one that got let go.
The one I let out of the can.
Yeah, well, we talked about that last week. You let him out of the can because you were riding so high with all of your knowledge that you basically told the court off and dishonored the court. I don't mean to embarrass you in front of the group. That's not my purpose. See, Ross has got, what, 3-4 months of intense training now, right?
Oh, yeah.
So you're a professional.
No.
And you were so excited about all the material and saw the power that it gave to you. And it gave you that sense of false security when you were in the hearing in front of the judge.
Yep.
And so you did all kinds of dishonors, but not, it doesn't make any difference. The lawyer that got out of the case said he'd still help you as long as you stay honorable.
Yep.
And of course, you're coming back and apologizing for the dumb things you're doing and get back on the right side.
Yeah.
You can always recover from something that you were in dishonor of that you did by a mistake.
Well, I need to talk to you after, because...
Okay.
Yeah,
We'll do that.
But
John? New paragraph.
Yeah, I believe the worm has turned, Jack.
Okay, John?
We're
yes,
getting...
I think the worm has turned.
We're getting things set right again. Reading from the Citizens Rule Book, the Jury Handbook, Article 1, Section 8, Clause 9. to constitute tribunals inferior to the all lowercase supreme with a capital C court, and that's us. We've given up our court. It's time for us to take it back. This is where the worm is turned.
Yes, these courts are statutory, legislative, administrative tribunals.
Absolutely.
They're not our courts, and we do err by going in there thinking that we're going to prevail judicially by bringing a law case argued in that court.
Right. Now, what I would like to say is, when we were going to meetings down in Columbus, Ohio, they had the one Supreme Court, as you know, with Larry as being the clerk of courts down there. And do you know that no other court in the military system would touch what we had already declared in that court?
Yes, actually, 5, 6 years ago, there was a rash of one Supreme Courts of the people all over the land.
Right.
And generally speaking, the public tribunals stayed away from everything they did unless the acts and actions of those courts trespassed on the public.
Amen.
But as long as they did not trespass on the public, literally the public tribunals stayed away, although there was harassment, there was publicity in the newspapers, all kinds of things to discourage things.
Right.
But remember, the outcome of those one Supreme Courts were nothing more than our own private administrative procedures in front of private witnesses. There would be the capacity to take those judgments or those findings under appropriate conditions.
Correct.
Into the public military tribunals for second witness and for execution.
And that's what they were doing.
Well, if it was done correctly, that's what could have been done.
Yeah.
Most of the patriots that set up the, quote, one Supreme Courts were of the mind and opinion that they did not need to transport their findings to any public tribunal for any reason.
Yeah,
and that's where they went wrong.
There were a certain few cases that went that way. Yeah, I remember that.
Yes.
But they did carry quite a few of them into the public tribunals to enter the paperwork into the tribunal courts. And they had several of them work out well.
Okay.
So
they should.
We maybe we're giving up our one Supreme Court to let the lesser tribunals take over.
Here is your problem, John.
Thank
You
you.
do not need that one Supreme Court that sticks out like a sore thumb against the public and is not quite so, quote, colorable as the private administrative actions we can do on our own. I'm not saying they're wrong.
Correct.
I'm just saying that as a political tool, they're too black and white, too truthful, too obvious against the democratic setting. And because of that, it embarrasses the public side and creates a form of dishonor if it's not held discreetly.
All right, I understand that. Yeah, I can see that.
But you see, the mindset of most of the people in those one Supreme Courts was that the government, the public side, was wrong.
Yes, you're
and
right
that was
about
an
that.
erroneous presumption.
Correct.
It would have been a correct presumption to just notice that the public acts in admiralty equity as an assumption and presumption unless the pleadings and the acts of the party guide it differently.
Okay.
In other words,
I can see
the observation of the patriots was that the public tribunals don't seem to be giving us a remedy we're looking for.
Right.
That's only because the so-called patriots assumed and presumed that you could not go into the public tribunals with a private administrative procedure in the law form and get a remedy, which it appears as though we can if we do it properly.
Okay, because I remember when you told us that the Creator created man, man created government, and the created could not become greater than its creator.
That is absolutely correct, but then we also went further and stated that government created persons. And it's the persons that the government is ruling over, not the people, unless the people attach themselves as chattel to the persons.
Like a barnacle to the bottom of a ship.
Absolutely, and that's what's happening. The people get trapped in because they put this attractive person out there that was created by the corporate government, and the people attach themselves to the person like a barnacle,
right,
becoming subject to the statutes that apply to the person.
Just like a rider article in an insurance policy.
Absolutely.
Okay, thank you, Jack.
Okay, very good. Now, when we noticed that these attorneys were opting to quit but then coming back to volunteer, we also started noticing, like we said, you know, in Ben's case, where the judgment of the court, the judge said that the defendant was found guilty and going to prison for 17 years for his actions. But then in the court proceeding, the judge clearly said, but Ben has been found guilty of the one count for which there was no prison sentence. It was all probation. And the judge even signed another document saying that Ben was eligible to be put onto probation. Remember, we said before the sentencing hearing that the judge had asked the prosecutor, would it be okay if we put the defendant on probation? And the prosecutor started yelling and screaming, no, this is a serious case. Absolutely not. No probation. The prosecutor just dishonored the judge's offer. So who's the creditor, the judge or the prosecutor? The judge. So when the judge held the sentencing hearing, he basically established two sentences in the public hearing. One in which the defendant's going to jail for 17 years, and one in which Ben is eligible for probation and might go home. What's this? Dual offer. One in equity. There is no money, so we can't close the account, so you got to serve in prison for 17 years. One in law. He offered his exemption to close the accounts, and if the accounts are closed, we can't put him in prison. There's no longer any debt to pay to society by putting him in prison. Now, after the sentencing, Ben's a little bit confused. Remember, that was about a month and a half ago or something, and we didn't understand what we've been talking about in these concepts like we have for the last week or two. So Ben goes back to jail, and for a while we're going, gee, when's he going to get out, if? And then we surmised maybe Ben isn't in jail on the criminal case anymore. Maybe he is in jail on the civil case under contempt. And so there is a form of confusion going on here, which they like to do, to see where Ben's going to go. Now, the thought has occurred to us that, remember, everything must be settled in 90 days if you're in a commercial contract. So the judge made a dual offering. Equity, 17 years in jail. Law, go home tomorrow. But the judge gave a dual execution for sentencing. He didn't give just one. Why didn't he give just one? Well, there are two forms. Well, yeah, he gave a judgment in each one, but then think of the poor people carrying out the judgment. The marshals, they go, gee, what are we going to do? Are we going to put him in jail for 17 years, or are we going to send him home? Hello? Do you see the government appealing this case to decide whether we got the right to throw him in jail or not? No. We don't see the government asking for clarification. Why not? They're going to sit back and watch him. What are they sitting back watching him for? 90 days. Why 90 days? There's got to be a resolution within the 90 days. You can't go to protest. A protester is in dishonor. Okay? The point is if you want law, who's got to execute the law? The private party must execute the law because they're the only one with commercial capacity to execute law. If the private party doesn't execute the law, the public will execute equity by default. Is the 17-year sentence equity or law? Equity. Going home tomorrow is the law. So if Ben doesn't do something in 90 days, it will default to the public side of equity, and Ben will go to prison for 17 years to discharge the public execution. Now, why didn't the judge just put it out in equity or in law? Why didn't he just grant one judgment or one execution of the judgment? Because there was no agreement between the two parties. The offender wants to go home on probation, and the prosecutor said, what? Over my dead body is this guy going home on probation. So when the judge went into the public hearing, he went, well, if they'd had an agreement, I could have given one decision. But because I saw honor in the offender, I asked the prosecutor, would you allow probation? And he said no, which was a dishonor. So with that dishonor, the judge was allowed to give a dual execution in the hearing. And the last thing the judge said before he left the bench was, you people get together and resolve this. What did the judge just do? He said, I've given you a new offer. The guy can go to jail or the guy can go home. You two people, the prosecutor and the offender, are the parties. You've got to have an agreement for me to give the public acceptance of to make a decision. So you guys get together with an agreement. Now, who's got the duty to do the negotiations on the agreement? Ben. Because if he don't get an agreement, the court will default to the equity execution, which is exactly what the prosecutor wants. So how does Ben get an agreement of the party? he has to make an offer to the prosecutor to show cause why probation isn't the remedy in execution. And if the prosecutor does not show cause, what happens? Default. What happens then? Dishonor. What happens then? Ben needs to bring an administrative record of the dishonor of the prosecution, which is an agreement of both parties, to the execution in law for probation. And he's got to bring that record back before the Honorable in open session to have the judge recognize the agreement of the parties is for probation. And it's got to be done within the 90 days by a petition back to the court. So he has to understand how to bring the agreement through a private record into the tribunal, and Ben has got to do this because no one else will. Now, Ben's attorney was one of the attorneys that dropped off the case by motion of the court. And when I talked to his wife Liz last week, that's when we started presuming that the reason Ben's attorney got off the case was to be on the private side to position himself by letter rogatory to set up these negotiations with the prosecutor if Ben has eyes to see and ears to hear. So Ben doesn't have to walk the paperwork through if he drafts the lawyer to do it under the proper letter rogatory. You understand how these things go? Yes, comment?
Yeah, going back to what John was talking about, the one Supreme Courts now, and we had them over in Euclid. You know, a lot of us were doing those quiet titles, and it seemed to me that's when the Sheriff's Department came in, and they were doing a lot of, people were walking in and out of there until we started making the statements to stay out if this is a private meeting. But would that be in the same characteristics as filing the UCC-1?
Well, the UCC-1 is with the public side of the military occupation government.
Yeah, but I'm saying if you've already had filed that quiet title.
In the county recorder's offices where they filed it. So now it became a public record, and if they certified that public record out of that public filing system, they could bring that certified record before a public tribunal to have the public tribunal take mandatory judicial notice of these acts and actions. And the issue is now that the public has been stopped by their failure to rebut the presumptions of the public filings.
Well, I saw a lot of the people that did that, but I don't think they really filed anything with the public. But I know that it got Cuyahoga County Sheriff's attention when a lot of people were starting to do that because he sent the head of his CID unit to those meetings over there.
Yes, I could see that they would be very interested in what was going on, but remember what they were doing on the public side was coming there to see if the people in those meetings were leaders, i.e. doing law, or followers running to execute on law without doing it.
But nothing ever became of it. They never bothered anybody, I guess, because they didn't try to go into the public with them, or they had no connection there.
Well, the private stuff they were doing in those private meetings is not illegal and unlawful. It would only be dishonorable had they brought those into the public without giving the public the ability to use a process to accept or deny it. It's like saying you go back to Genesis 23 and here's Abram trying to buy a parcel of land to bury his wife Rachel on, and what's what's basically going on is that he did the private negotiations and agreements. But then he came back and in the open public square made public all of the agreements and decisions. He didn't say, because these people are foreign to me, I don't give a hoot about what they say or what they think, so my private documents are more important than their public assumption and presumption of them. No, he was in a foreign land, so he brought his private agreements before their public as a witness.
That's exactly what I did with my quiet title. I knew or had an inkling who the guy was, who at the time was the head of the CID for the Sheriff's Department. And as much as he didn't want to, I made him be one of the 12 people that signed that in on my quiet title, so they had notice of what was going on.
Correct.
Nothing ever came up. And he couldn't say he didn't know what was going on because he was there. And after that, I found out, I used to go to St. Jim with him, and I found out that he was in the throes of retirement, but that's what he told me, what he was just going there to see if everybody, who was instigating what.
Mm-hmm. Very good. By the way, to correct an error on the tape, it's Sarah, not Rachel.
It's who?
Sarah.
Sarah.
Sarah is the wife of Abraham.
Oh, to get back to that, that's 4,000 years ago. That war's still going on between what was it?
Absolutely.
Yeah.
But if you remember right, Abraham acquired the land for the burial plot, which later became Bethlehem.
Mm-hmm.
And I don't think anybody really got good legal title back from Abraham since that time.
Well, that's what I'm saying. Israel and Palestinians are arguing over that for the last 4,000 years.
Yeah, I think it belongs to Abraham's posterity, and I don't think either one of those groups of people there belong to that.
Yeah,
so.
I don't think Israel ever rebutted that fact either.
There you go. You got it. Okay? New paragraph. In light of what we're talking about in this dual capacity of attorneys, there are some people in this room that have some cases going, and I've always noticed that when you're up against an opponent, you get two kinds of communications from the attorney of your opponent. You get his telephone calls to you. You get his letters, even when you get a copy of a public filing from the attorney by service of process from your opponent. He usually always includes a letter with it describing certain things. And the thought started occurring to me that the letters and the phone calls you get from the attorney for the opponent is like private letterogatories. Those letters and those phone calls never appear in the official court proceedings. And usually that attorney will talk to you or write to you anywhere from several weeks to 7 days or 10 days before he turns whatever he put in his letter or his phone call into a public filing in the court. And the thought occurred to me that the most important communication you have with the attorney of your opponent is the phone call and the private letters, because that's probably on the law side of the case. And because you dishonor what he's doing there in his phone calls and his letters, it results in an equity filing in the public tribunal. The reason I raise this issue is because we said that every attorney represents both sides of the cases and both law forms in the case, both law and equity. And in fact, when I was involved in cases, the best case law describing the technicalities of the acts and actions going on behind the scenes usually always came in the brief and memorandum from the attorney for the opposite side. If you looked up his cases, they generally all favored your position. So when you talk about dual offerings, law and equity, the attorneys are giving you the law in their private communications and the equity in their public filings. So pay attention to what they're doing. Now that we have eyes to see and ears to hear what's going on, it's incredible what we're finding. I had my friend from up in the New England area call me, and he had a couple of interesting comments. His first comment was that if you look up the term offender, as we've been calling ourselves for the last several months, he said the term offender in the law dictionary, it basically says the following. An offender is a person convicted of a crime. And so Jeff said to me, do you really want to rethink the concept of calling ourselves offenders? Because if you call yourself an offender according to the law dictionary, it says it's a person convicted of a crime. Jeff once again suggested that the term aggrieved party better fits the living soul. Because an aggrieved party is one brought into a matter who's a third party. And even though he's brought into the matter as though he's got some kind of a duty associated with that matter, he's not directly involved per se. He is a third party. Now, Jeff brought me that definition, one convicted of a crime, and you know that fits perfectly with some research that's done by another friend of mine who happens to be in jail or prison out west. And he called me on the phone a couple of weeks ago, and my buddy said to me, in my studies of the United States statutes and the Code of Federal Regulations, the only persons that the United States puts into the federal prison system is offenders. Every part of the Code of Federal Regulations dealing with those people taken into custody to reside in the federal prisons are referred to in the statutes and the Code of Federal Regulations consistently as offenders. Which is very strange because there are no offenders charged in any of the charging instruments. There are always defendants charged. But somewhere along the way, a person called an offender becomes liable for the sentencing execution of the judges. Caleb.
29, I just lost it. 03, pre-plea remedy or pre-plea objections in the codes even classify you as the aggrieved party rather than the offender before you make your plea.
That's true in Ohio Revised Code. So they call yourself an aggrieved party. So certainly we may want to reconsider what kind of a handle we're putting on us, the living souls in these cases, because we're taking great pains not to come in and argue those cases as an officer of the court or get involved in any of that kind of activity. Now, the next thing that Jeff brought up to me is he said there is another legal term in the dictionary. I thought I'd put that somewhere in here. Maybe I was wrong. Only one more. Jeff's got a legal dictionary. It's got 2 terms in it. His is a concise, abbreviated version. And in this particular one, this is New Hampshire, Jeff. In this particular one, I should probably get the paperwork so I don't get it wrong. Maybe I'll find it here. He was not going on an acceptance for value. There is another term in the law dictionary, acceptance for, and it'll come to me in a minute, and it's so incredible as to the legal definition of what that means that, no, not accepted for assessed value. Has nothing to do with that. I'll check it out later on if I've got time. If not, I'll bring it to you next week. Next thing, got feedback from my friend Idaho Nick, who is, remember the last time I told you about Idaho Nick, he has literally got that ground pilot school going out there at the county level community college, and this ground school is so incredible because since Nick serves and donates his time, actually the school has no expenses, no teacher, no anything. All they got to do is provide a classroom. And so I believe that all these students are coming to learn flying ground school for like a total investment of $0. And this thing is just absolutely escalating. Wasn't it just about every man's dream or boy's dream to leave the ground and fly in the sky? But then when you make your first visit to the airport ground school and find out it's probably going to cost you about like $3,500 in tuition to go through the ground school before you get your feet off the ground, all of a sudden reality of the Babylonian kingdom sets in and you're perfectly happy just watching the airplanes fly overhead for a while out of economic consideration. So our friend Nick's school has been climbing and climbing in attendance as more people find out about the great opportunity. Well, Nick told me in a discussion I had with him yesterday that things are moving quite quickly now. Now, remember, we're in Idaho. They don't have any flat land there to land airplanes on. So there's no other ground schools anywhere around that he's in competition with. So there's no commercial people complaining about this endeavor. So I'm not exactly sure what kind of a helicopter or airplane they're thinking of, since there's no flat land anyplace in Idaho. However, Nick did tell me that there must be a miracle. They must be cleaning off the top of a mountain or something, because the county now has plans, or these people that Nick's working with have plans to actually get a real live airplane in there to continue the process beyond the mere ground school. And they're thinking in some way, shape, and form that they're going to put together a package so that that airplane would be readily available to almost any of these students for like next to nothing or something to proceed on with where they're going. So I'll let you know how Nick's doing at destroying aeronautical commerce in Idaho by actually serving his fellow man and fulfilling their dreams as time goes by. And I mean, I guess everybody there is really, really excited about this. Nick came to me, though, and he said, I've really got to give you a bad time, Smith, about your last couple of Monday night tapes. He said, it's very interesting that we're starting to understand that in their public statutes and codes that there's law interspersed between the equity, so that one is eligible to gain a remedy in law through equity. Notwithstanding, he says, the problem that I've got with what you're doing, Smith, is that there's going to be a lot of people out there that are actually going to believe that you're giving them a remedy by telling them that the statutes and the rules and the regulations provide for law remedy in their proceedings. Now, Nick said, and I said, Nick, you and I are not in disagreement. Here is your problem. In order to qualify for remedy in law, what do you need? No, not a remedy in equity. That's how you're ultimately going to get your remedy in law. Wash your hands in law. What's that mean? It means you have to have standing and character. Can a slave go to law for a remedy? No. A slave has no standing or legal character for a remedy in law. Consequently, just because the law can provide a remedy does not mean everyone is entitled to a remedy in law. Before one can get remedy in law, one has to have standing and character in law to qualify for the remedy. To put it the other way, because you understand that there is a procedure in law and a statutory remedy in law, does not equate with you have standing and entitlement to that remedy and that procedure. Like the party in the back so adequately said, you must first wash your hands in law to get your law remedy from an equity court. A slave cannot wash his hands in law to have the standing to allow the equity court to give him the remedy of law. So just because we are giving you notice that the lawyers, the courts, the statutes, the rules, the Code of Federal Regulations provide a procedure and a capacity, does not automatically equate that everyone is entitled to that at any one time. So there are going to be people that are going to pick up the tapes and they're going to hear, hey, did you see where the state of Ohio gave you a law remedy in the statutes and the codes? And they're actually going to try to go into a proceedings to invoke those procedures, and the equity court will deny the remedy. Then they're going to say, well, that doesn't work. When the reality is they didn't have standing and character to invoke it. Let me give you an example. I have a group of people that I've been tutoring right now that are just wonderful people. They're some of my favorite tutors. And I'm going to have a tutor with them tomorrow because they've already faxed me and told me that they've got further problems along the line of what we've tutored them before in the past. And it appeared as though for a period of time they were getting a remedy. However, the prosecutor in this state has again come after them in the same issue. No, it wasn't even 90 days later, it was 30 days. Now, these people have tendered a bill of exchange to discharge a tax liability. And they used the exemption of the straw man to do it. But the Attorney General for this state keeps pushing a garnishment in a corporation against their earnings. What's the problem here?